Bob, what's the difference between earnest money deposit and a contract deposit?
Well, Jason, there are a lot of differences between the earnest money deposit and a contract deposit. Earnest money refers to a deposit you may put down after you see a house and you like it. Say, for instance, you go out with a broker, you see a house is priced, say, $500,000. You offer $475,000, they counter. You agree on maybe $490,000 as the sale price. The broker will then reduce that to a writing on forms that are supplied locally to real estates. And then as a token, they will ask the buyer to put some money down as earnest money to show that they're really interested. And typically that money ranges anywhere from a mere token, $100 to $1,000. That earnest money should be held by the real estate broker. It should not be given to the seller. You should give it to a neutral party. And honestly, real estate attorneys don't give much importance to either the document called the binder or that earnest money deposit. We feel that the earnest money deposit is only a token. It's only symbolic. It's really not any sort of legally enforceable deposit. And the agreement that the broker writes up, although it's a standardized form, may only contain, say, 5 different topics that a true real estate contract should contain. So the more important of the two deposits is the contract deposit. That's when you go to an attorney's office, they have a contract. Contract could be 5 to 10 pages, maybe 25 to 50 different clauses, contingencies, time frames, expenses. And once you sign that contract and you would put down a deposit, traditionally 10%, those are meaningful documents and deposits. The contract is a meaningful document, it's legally enforceable. The down payment is substantial, usually 10%. It'll be held by the seller's attorney in escrow. And those are documents and deposits that you can rely on and know that your real estate transaction will start to move forward, hopefully to a successful conclusion. You'll end up buying the property. If for some reason the deal falls through, well, then you have to discuss with your attorney the ramifications of whether you get the deposit back, or in some cases, if you refuse to buy, you change your mind, you may not get the deposit. So attorneys really focus on meaningful acts. Meaningful act is signing a contract, putting down a 10% deposit. Before that, mostly symbolic. I agree to buy your house for $490,000, and I may give you $100, $200, $300, $1,000 as an earnest money deposit. But those aren't too meaningful, questionable legal enforceability. We'd rather go with the deposit and the contract and know we have a real substantial real estate deal. And that, Jason, is the difference between an earnest money deposit and a real estate deposit on a signing of a contract.